So what I want to hear now, do you have any evidence you're going to produce myself? No. So what I want to hear now is I want to hear argument. And let's, for the moment, let's talk about, we know what the arguments are, I think, generally with regard to the birth certificate issue. Let's talk about the natural born citizen issue, which is a legal issue. And I mean, to do with the evidence here. As I've said, we can take this in the context of the fact that it is a well-known fact, certainly nothing that the president would deny or his campaign would deny. That his father was not born in the United States, and his father was never a citizen of the United States. Now, in that context, counsel, Mr. Purpura, you have already discussed partly, I don't say partly, you've already mentioned some of the position that you raised, and you argued it extensively in the brief. And you've mentioned a couple of United States Supreme Court cases coming to us from back in the 1800s that deal with this issue in one form or another, because I think it's fair to say that, to my knowledge, there has never been a direct ruling in the context of a presidential campaign or such on the issue of natural-born citizen. It could have come up, I gather, it would have been warned, interestingly, in the Chester A. Arthur case, but it was not ruled on in that matter because they had another issue about whether he had been born in Canada. So the issue of what natural-born citizen, I gather that that was not actually ever ruled on. So there is no decision that I'm aware of, and I don't think either, well, of course, Michelle hasn't filed anything. Is there now, there have been decisions in the context of this, I understand, in the context of Mr. Obama, but before that, before the Obama controversy. The issue has come up before. It came up with regard to George Romney, who was actually born in Mexico, and there was some, which I actually don't recall the exact detail of why it was concluded that he was legally allowed to run. Not Mitt Romney, but George Romney's father. And it's come up, of course, with Senator McCain, because he was born in the Canal Zone, although his father was in the military. But in the context that's come up here, where it's not a child of a military person, and there wasn't the unique circumstance that involved the Mormons, I think, in terms of why certain Mormons were in Mexico, which I think is why Mr. Romney was allowed, although I haven't looked at that. This issue has not been decided prior to the Obama issue by any court that I know of, certainly not by the Supreme Court of the United States. So with that said, we have some case law that is discussed in other contexts, have discussed the issue of common law, non-common law, and so forth. Is there more you want to add to your argument, Mr. Purpura, than you said earlier in the discussion today and what you said in your brief before I hear from you, Senator? Will I address counsel?
Yeah, well, I would just like to highlight that we have to go, first of all, we're going to understand what the natural-born citizen clause means. We can't just look to a case in 1898, Ron K. Mark, and say, oh, here's what it says. Oh, therefore, that person was ruled a natural-born citizen, which the holding does not say that. It doesn't say he's a natural-born citizen. It says he's a citizen. Okay? But the point there is that
he didn't have to be a natural-born citizen.
He didn't have to be, exactly. Yeah, I've said that time and time again.
But, well, go ahead, because I don't want to get into it. I have some questions I have to but I want to let Ms. Hill give her argument before I do that. So go ahead.
Yeah. So. Clearly, all he had to do was a citizen, so he wasn't getting deported from the country, which is the standard today also. If you're a citizen, doesn't matter how, naturalized, derivative, acquired citizenship, born a citizen, there's all kinds of different citizens, how you can become a citizen. And all those situations where you're a citizen, they're all born with some kind of alienage, either because they're not born on the soil, or because they're born to one or two alien parents. Now, of course, if you're born outside the country to aliens, you have to naturalize after birth. Okay? But if you're born either here or abroad to at least one citizen parent, you could be a born citizen of the United States, but you're still naturalized because you have alienage when you're born, either because you were born on foreign soil or because you were born to an alien parent. And the reason for the alien parent is because of jus sanguinis, which goes back to time immemorial, inheriting citizenship and allegiance from parents. And jus soli, acquiring citizenship and allegiance from the soil. Okay, so either one of those can give you alienage, either one. Now, Your Honor mentioned McCain. Now, here's a perfect example. There's an exception If you're born abroad and you're in the military, your parents, what does the common law say about that? Well, again, why do I say common law? Because that same common law tells us what a natural born citizen is, which would include McCain. Let's not get off on this tangent with McCain. But the reason why I mention McCain is because it's the law that applies to tell us if someone is a natural born citizen. So when you go back to the founding members, they look to the natural law and the law of nations for a tremendous amount of law that they were dealing with, because they couldn't use the English common law anymore. Because
Why couldn't they use the English common law?
well, because they just overthrew the British control.
Why couldn't they use the English common law?
Because first of all, the English common law was for the monarchy, okay? And there's a lot of historical evidence that with Madison, he even writes a letter, says we couldn't, we went at the convention, we couldn't adopt the English common law. How are we going to adopt the English common law? Well, we're going to bring all this monarchy and all these things that we broke away from. We're going to bring it over here again. I mean, that's what I said in my brief, because there's a ton of other information that's not in the brief. That's just an objection. But the point is that the common law, the English common law, was allowed to continue on the state level. Okay, and that's not in dispute. Torts, marriage, criminal procedure, contracts, inheritance, on and on it goes, because we had to maintain a society. We had to maintain it. We didn't revert to a state of nature. We had to maintain order. So we continued under the English common law on the state level, but not on the national level. The Constitution in Article 3 tells us the laws of the United States. What are the laws of the United States? Now, not state law, United States. Well, it was the Constitution, it was treaties, acts of Congress, and the law of nations. And there's plenty of...
Have you read Juan Mark?
Yes, Juan Mark, yes.
Let me hear what you have to say about Juan Mark before I go against.
Yeah, well, Juan Mark, what happens there is that we have a new type of citizenship that the court is looking at. Never been decided before. A child born in the United States to alien parents. So what the court does is, and the court actually did it for policy reasons. Okay?
No, that doesn't mean what they did for policy reasons. I don't know what they said in the decision.
Yeah, what they said was that a child born in the United States to domicile alien parents is considered born subject to...
Is that what they actually said, that they had a domiciled alien parents?
Yes, domicile.
Where in that decision does it say that?
It's right in the holding. I don't have it right in front of me here, but it's stated more than once.
Okay.
Domicile is very important, Your Honor. It replaced citizenship. That's how important it is. See, the United States became a nation that looked to domicile in order to make you a citizen. That's what happened with Juan. Because before that, your parents had to be citizens. And the statutes of Congress started in 1790, then 1795, then 1802, then 1855. These are all...
You mentioned those. You didn't explain what your reference was to them. What in those statutes is relevant to the question before you?
It proves that Mr. Obama cannot be a natural born citizen.
How does it prove?
It proves
What does it say?
Very easy, very
What does it
easy.
say?
It proves it by exclusion. Because the statute says that you have people who become naturalized. Okay? Now, a naturalized person is somebody who's not born here. Okay? Once that person naturalizes, his children or her children can become American citizens.
Okay.
Okay?
That's not the situation.
Well, right. Well, yeah, that's what, exactly, Your Honor. See,
So how does that speak to this situation?
Well, very easy. If this happened, what we have happening today, if this happened in 1790,
You said this is in 1790.
no, but I'm answering Your Honor's question. Okay? If this happened in 1790, Mr. Obama would be a natural-born British subject. He would not be a U.S. citizen because his father never naturalized. And back then, you had the wife automatically took on the citizenship of the parent, automatically. You have British statutes on the books that said if you're born out of the dominions to a natural-born British subject, you're a British subject for life. Okay? So the British Nationality Acts that existed then,
Right. Made his father a British citizen.
his father was British. His son,
What does that have to do with Mr. Obama?
well, a lot, Your Honor. We're talking about what
On the assumption, because remember, of course, we understand that this whole argument a natural born, is based, you know, we put this in the context, is based on a conclusion, because it doesn't, otherwise it's not relevant, that he actually was born in the United States. So we're assuming for the purpose of this argument
Yes.
that Mr. Obama was born in the
Yes,
United
Your Honor.
States.
Yes, but the point is, it's not sufficient. We even have, there's even an article in an old newspaper written by Publius, okay, which probably was Madison, because the three of them were Publius, so because of the age of it, and it says clearly right there that the individual was born in America. He was born in America, and I could provide this to Your Honor, if I can even fax it this afternoon sometime, that the individual was born in America, and the argument was, oh, he's born in America, he's a citizen. And Publius said, no, we don't have such a law. If you're born in America, that's not sufficient. Your parents got to be citizens. This was Madison. In an old newspaper, this is a very valuable find, which that particular article went to the statute of 1802, because that's what was being argued at that point, which is the same as 1790 and 1795 on the language that I just cited. That if, in other words,
This position in your argument been accepted in any court? In regard to this argument concerning, let's say, I don't want to jump the argument, I'm not sure, but I want to ask counsel.
yes,
Because you're making the argument. The argument has been made that Mr. Obama is not a natural born citizen. And I am by far not the first judge in this country to be presented with this argument, correct?
that's correct, Your Honor.
Is any court at all, appellate, federal, state, administrative, any court at all accepted the argument that he is not a natural born citizen?
Okay, I can speak about the cases that I've been involved in.
Well, I assume you, well, all right, well, let's take the cases you've been involved in.
Yeah, I was involved in the Kirchner versus Obama Congress case, which went to the U.S. Supreme Court. It was denied cert. The case was dismissed on standing. And the court in the Third Circuit said, we cannot decide whether the American common law definition of a natural born citizen is still continuous.
When they say we could decide it, the case was dismissed for standing. So
Right,
they have
exactly.
to decide it.
That's exactly right. So
the answer is that they didn't rule.
no, they did not rule, but they...
That's a different. I asked you if any court has accepted your position. I understand that some courts on standing haven't chosen to even discuss it, but we're not talking about that. I'm asking you, is there a court that has ruled on the issue, on the merits of the issue, that has accepted your position that he is not a natural born citizen?
No, but the case law as it exists shows what a natural born citizen is.
So in other words, every court, and you're entitled to your opinion, I understand that, but every court that has ruled on the merits on the issue, state, federal, administrative, every court that has rejected this, misread the law, misunderstood the law, misunderstood the United States Supreme Court discussions that have gone through this issue, at least in terms of extensively referring to natural born, they were all wrong.
Well, Your Honor, first of all, a lot of them were procedural, like finding standing.
Counsel, with all due respect, counsel,
Yeah.
I didn't ask you about standing. I know there are cases that were dismissed for standing. Those cases are on the merits. And I'm asking you, on the merits, is there a single court that has accepted this? And you told me no.
No, there is a case in Indiana which actually said that all you have to be is born in America. It doesn't matter what your circumstances are. But now that case did not rule that Mr. Obama was a natural born citizen or that he was born in America. They never
Well, we're not talking about whether he was born in America, because that issue I understand. He wasn't born in America. We don't have to talk about natural born. We're talking about now the second portion of your case. If you win the first portion of your case, we don't even get to this.
Yes. The point is that any case that has dealt with this issue, there's a federal case called Tisdale in the Fourth Circuit.
Right.
Okay, and Judge Gibbons said that, he cites Hollander for the proposition of what a natural born citizen is, and Hollander was a standing case. But be that as it may, there are some cases, also down in, I think Georgia might have touched it.
Judge Milley's
decision? I think he does say that.
He does?
Yeah, I'm pretty sure that he...
Yes, I have Judge Milley's decision right here.
Yes.
I happen to know Judge Milley.
Oh. Yes.
And he did discuss this. it's some, and he referred to the Indiana decision.
Yes, that's right,
Did he
yes.
not? And he didn't accept your position, did he?
No, it doesn't mean that I'm incorrect.
Oh, you're telling me your opinion.
What it means, why? Because first of all,
I'm asking you if there's a legal authority
Yeah.
in court that has accepted this position.
Okay.
Your advocate, because this position has been argued, well, there have been standing cases and so forth, so I haven't counted how many times, but there are certainly, I suspect, dozens, I think, that have, around the country where the issue has been raised.
No, raised, like
Raised.
100, I guess.
Oh, yeah.
Yeah, 100.
Yes.
Raised, but
Now, some of them have not decided it because of standing and so forth, but I'm asking you, is there a court that has accepted?
Yes, very simple, Your Honor. Judge Maley's decision there. Does he address the statutes that I mentioned? Does he address Vattel? Does he address natural law and the law of nations? Does he address minor? He says that, I think he says minor is, he doesn't explain minor. He doesn't even discuss it.
No, he says the minor court left the issue open.
Yeah, but then if I say issue, what issue?
Then he talks extensively about Moran.
Yeah, but
You seem to want to dismiss
Oh, no,
the
no.
extensive discussion in Moran
Oh, no, I'll
about
address
the English
Moran.
common law and whether the English common law applied at the time of the Constitution was adopted.
Yes, I'll address that, Your Honor. But first of all, on minor, you said that they left the issue open. What issue? Not the issue of what a natural born citizen is.
Well, that's what he says.
Well, but that's, yes.
Yeah,
It's not-
I will read it.
Yes, you're right. Look at minor, okay? The question is, what issue was left open? Not what a natural born citizen is. The issue that was left open was whether the person is a citizen under the 14th Amendment. A citizen under the 14th Amendment. The 14th Amendment doesn't say natural born citizen. If you go back to Article 2, it says the citizens of the United States are eligible, provided that they're citizens at the time of the adoption of the Constitution. Okay? So if you're going to show me you're a citizen, well then you better have been born in 17 whatever. Okay? If you want to be a president today,
Doesn't it say in Ron Kim, reading now from Judge Keene, reading from the decision in Keene versus Governor of Indiana,
yes.
which is at 916 Northeast 2nd, 678, the decision of the Court of Appeals of Indiana. And it says, in referring to Wan Kim Park, the judge says, we affirm minor in that the meaning of the words, quote, citizen of the United States, unquote, and, quote, natural born citizen of the United States, unquote, must be interpreted in light of the, quote, must be interpreted in light of the common law, the principles and history of which were familiarly known to the framers of the Constitution. And then he goes on to quote extensively from Wan Kim Park, where they go into an extremely interesting and lengthy discussion about the English authorities and the English understanding of what it meant, and, quote, the same rules in force in all of the English colonies upon this continent down to the time of the Declaration of Independence and in the United States afterwards and continued to prevail under the Constitution as originally established. Doesn't that say that English common law, whatever that was, whatever the definitions of English common law were, that was what was adopted in the Constitution?
With all due respect to the United States Supreme Court and to Justice Gray, there's no support for what he says. And very simply,
he seems to think he's writing an awful lot of support in his decision.
but, he gave a lot of support for the wrong thing. He told us about states. The states. Yes, that's not in dispute. The states put it in their constitutions. The states put it in their statutes. But the national government did not put the English common law as defining citizenship. If it did, then why do we have the naturalization statutes that I just cited? That say, if you're born here, that's not sufficient. There's no jus soli. It's jus sanguinis. Why do we have the Venus case? Chief Justice Marshall telling us what a native or indigenous is. Why do we have English? I've cited you. Minor. Why does minor tell us that you have to have citizen parents if the English common law prevailed to define citizenship? Wan Kim Park confirms minor. It cites minor and gives the definition of a natural born citizen. Wan Kim Park. But then it says, we're not dealing with a natural born citizen, we're dealing with a citizen.
All right, Counsel, I don't want to, I mean, if you have some more salient points, I'll hear them, but I don't want to cut you, but it is starting to get on here, and I do have some work to do.
Yes, Your Honor.
So and you've made the arguments in the brief as well. So is there anything more you want to specifically point out?
Yeah, one last
Before I
thing.
hear from
Yeah,
Ms.
one last thing is very, very important. St. George Tucker, and I've mentioned.
You mentioned St. George.
Yeah, now he's a fascinating individual, and what happens is St. George Tucker, he wrote it's called Commentaries on Blackstone. Why did he write it? He wrote it to show that the American common law was different from English common law. He took it from his lectures at the William and Mary law school, where they taught the Calvin natural law and the law of nations. Very important. Justice Marshall was there. Wyatt was the professor. Jefferson,
Yes.
Tucker. These are the heavy intellectuals of our founding. But the point is that he writes that citizenship, okay, can be either acquired or inherited. Okay, it's acquired if you're naturalized. It's inherited. If you get it from your parents, only if you get it from your parents is it inherited. This is one of our founders. And then he says that the right to run for president is a civil right, which only belongs to citizens, but not a natural-born citizen. Excuse me, not a naturalized citizen. Only the children of citizens have the right to run for president. He says it right in his. Only the children of citizens have the civil right to run for president. This is St. George Tucker in his commentaries, which completely obliterates Blackstone. Because Blackstone said, you're a natural-born subject if you're born in the dominions, under the obedience or under the allegiance of the king. That's not the law that we adopted. Again, it's clear as day. The statutes abrogated. The statutes that I cited abrogated English common law on the national level. Okay?
Ms. Hill?
Okay. That's all very interesting and a good argument, but it's not evidence in this case. If we go back to some of the cases that Your Honor mentioned, for example, Ankeny versus Daniel says that based on the language of Article 2, Section 1, Clause 4, and the guidance provided by Wong Kim R., we conclude that persons born within the borders of the United States are natural-born citizens for Article 2, Section 1 purposes, regardless of the citizenship of their parents. Additionally, in the Moran case in Georgia,
That's Judge Maloney's
Yes, would you
decision,
like
which
us-
is, no, I have the decision, and that, for the record, was Farrar. There were several cases,
Yes.
but it's Farrar versus Obama, which is the lead case.
in that case, they rejected the challenge to Obama's eligibility to appear on the 2012 ballot, finding that Obama was born in the United States and is a natural-born citizen. Federal and state courts around the country have consistently recognized that a person born in the United States is a natural-born citizen, regardless of the citizenship of the person's parents, regardless of whether the person holds dual citizenship. For example, in Galvez versus Bridgestone Court, recognizing that children born in the United States and Mexican parents living in Mexico are nonetheless natural-born citizens. Another example is Perkins versus L. Is that the site?
Yeah,
Okay.
I think, yeah.
307 U.S. 325. A person born in the United States to naturalized Swedish parents was a natural-born citizen even though she obtained Swedish citizenship under that country's laws. Another case, Yamaguchi versus Rogers, 181, F-Sup 934, 935 to 36, recognizes that a child born in the United States to Japanese nationals was a natural-born citizen.
Well,
I mean, it's time and time again. The bottom line is that a child born in the United States, the parents, and I wanted to also mention, in the Tisdale versus Obama case that was brought up by counsel, it was ultimately they dismissed the complaint challenging Obama's eligibility, finding that Obama is a natural-born citizen because he's born in Hawaii.
Your Honor, those cases those were factual statements. There was no analysis of what a natural-born citizen is.
You know, it's actual statements. There's the whole-
Yeah.
Sorry, that's what
Oh, I thought.
Go ahead, Ms. I think you said something.
For example, and then also in Fat versus White, 253 U.S. 454, a reversal lower court ruling against a person who claimed he was born in the United States to Chinese parents and holding it is better that my child's immigrant should be properly admitted than one natural-born citizen of the United States should be permanently excluded from the country. I could keep going, but we've had enough.
Yeah, I just want to say very quickly, Your Honor, that those cases, there's no analysis what a natural-born citizen is. It's just assumed. It's assumed in the facts. In the facts. In other words,
Aren't
it's
those
like,
the holdings in those
oh,
cases?
absolutely not, Your Honor. That's not the issue. The issue is not, they're just in the facts that the court says, oh, this child born of Mexican parents is a natural born citizen. It's, in other words, when they set out the facts. Okay? Yeah, that's not, the issue is not what a natural born citizen is in the case. So it's like super dicta.
Well, in a sense, what you're saying, I guess, counsel, is that because the natural born citizen issue only is relevant to the president and candidates for president. Right?
Yes.
Every other discussion about citizen is relevant to the more general population, shall I say. But, I understand that. But one of the elements that in the Wang Kim Ark case, and in the discussion, which is an extensive discussion of the English common law and its application to the United States and so forth, they continually reference not only the term citizen, but also the term natural born subjects, natural born citizen, so that, you know, while it may be true, and I think it is true, that in Wang Kim Ark, one could say that the issue of what natural born citizen was not, if you want to vaguely say it was dicta, that discussion as it affects that term, I suppose one could perhaps say that, because the issue there was not about a presidential candidate. But at the same time, the discussion in depth is about what those terms mean in the English common law, and also, again, to the extent that they conclude that, as I read the case, that they conclude that it was applicable in the United States under the Constitution. And they refer over and over, and the judge in Kennedy, which is the Indiana case, quotes only a portion of a very lengthy discussion, and they continually refer to the meaning of natural born, natural-born, which is the same language used in the Constitution, natural-born. And so, you know, obviously we aren't talking about subjects in the United States, we're talking about citizens, but the, quote, natural born, it's a hyphen, natural-born, is discussed quite a bit here. So, you know, we can debate whether or not the fact that they discussed it is somehow dicta, but nevertheless, I think that it's fair to say that the position that you are arguing, if you have more you want to say,
yeah, one other point
before I go on.
Yes, just when you look at the Wang Kim Ark case, Your Honor, in studying this, one of the keys. Okay, first of all, the whole discussion about English common law is only to make a citizen of the United States under 14th Amendment. It's not to make a natural born citizen. Okay, but the case itself.
No, I don't know if it's not to make a natural born citizen, because the issue in the case was not about the question of natural born citizen, but whether it defines what natural born citizen is, even though that wasn't necessary to decide for Mr. Ark, which arguably could make that discussion to that extent dicta. To say that the discussion isn't about what natural born citizen means, I'm not sure you can go that far, because they discuss it and use that phrase over and over and over in the discussion. So, yes, they didn't have to decide that for Mr. Ark.
Yeah,
correct.
One of the errors, one of them, there are many, one of the errors made is conflating what a citizen is, what a natural born citizen is. Article 2 tells us you can't do that. Marbury versus Madison said every clause in the Constitution has value. You can't just blend clauses together and assume they mean the same thing. If you're going to do that, then show us that they mean the same thing. But Article 2 says if you're a citizen, you could be president if you're born at the founding, okay, if you're a citizen. If you're born after the adoption of the Constitution, you've got to be a natural born citizen.
Right.
So the 14th Amendment says citizen. It does not say natural born citizen. So how can we just throw away the natural born citizen clause, conflate it, confound it, and just say, oh, well, that's what it means, and that's
I'm not sure that that's what the court did in Wang Kim Ark.
No, they did not do that.
They didn't do that. They
No.
said, here's what natural born citizen means.
Oh, they didn't say that. Absolutely not. And here's my further proof. Further proof is that the court says, referring to a paper of Philadelphia lawyer Horace Binning.
Yes.
Okay, he wrote 3 papers The second edition is what Justice Gray cited for. The second edition says in the footnote, the very famous footnote, says that a child born in the country, the aliens, is as much a citizen as a natural born child born in the country of citizen parents. It's right in there. So what does that tell you? Okay, that they're both citizens. They're both as much a citizen, but the other one is a natural born citizen.
All right, anything else you want to add?
That's it.
All right.